Hey guys, it's Mo from Mo in the Deep End, and as promised, I am doing the Yeeted Rossi files. I probably should have done this video first, to be very honest with you, if we're going in like chronological order, but I am an agent of chaos. But sometimes life is not chronological or in order, or, in my life, even slightly ducks in a row. So these are the yeeted filings of attorney Bradley Rossi. This is the first one. Verified notice of continuing representation. Now, these were all yeeted by Judge Frances Gull after she decided that she would take the oral promise of Mr. Rossi that he would, recuse himself from the case or withdraw representation. Again, Mr. Allen wants his attorneys. He has built a rapport. This is, something that generally is done when, you know, there are steps to take to remove attorneys. It is a formal, there are due process issues involved. Verified notice of continuing representation comes now attorney Bradley A. Rossi, counseled for Richard M. Allen, and in support of his verified notice of continuing representation, now swears and affirm as follows. 1. On November 14th, 2022, counsel entered his appearance on behalf of Richard M. Allen. Counsel has engaged in continuous representation of defendant Allen since this date and time. 2. On October 12th, 2023, the court communicated with Prosecutor McClelland, Attorney Rossi, and Attorney Baldwin, at which time the court ordered attorneys Rossi and Baldwin, quote, cease work on Mr. Allen's case, end quote, until parties were set to appear in court on October 19th, 2023. The chilling effect of the court's emailed order was essentially to strip the defendant Allen of his Sixth Amendment right to representation and essentially disarm attorney Rossi and Baldwin and defendant Allen during the week leading up to the scheduled, quote, hearing, which was ordered by the court sua sponte. 3. In an October 17th, 2023 email, attorney Rossi requested a conference to determine, quote, what we, brackets, the court, prosecutor, and defense counsel are trying to accomplish on Thursday, especially in terms of what is expected of us while we are on court in open record. Question mark, end quote. In response, the court ordered both the defense and prosecutor to appear in chambers at 12:30 p.m. on October 19th. 4. On October 19th, 2023, attorneys Rossi and Baldwin appeared at the Allen County Courthouse in advance of the 2:30 hearing. This was prompted by attorney Rossi requesting that the parties communicate in advance of the scheduled hearing. 5. Attorneys Rossi and Baldwin appeared in chambers on the 19th at approximately 12:30 p.m., at which time the prosecution was present. Attorney Rossi is of the understanding that the court reporter secured an audio recording of in-conference chambers, which took place in two parts. 6. The court first conducted business as it related to several pending motions by communicating with the parties and issuing rulings on said motions. 7. The court then read a prepared statement to attorneys Rossi and Baldwin identifying various issues through the case through which attorneys Rossi and Baldwin exercised, quote, gross negligence, end quote, in carrying out their responsibilities as counsel for the defendant. The court then suggested that attorneys Rossi and Baldwin engage in a discussion outside chambers regarding the allegations. Attorneys Rossi and Baldwin asked for clarification, at which time the court communicated to the attorneys Rossi and Baldwin that there were two distinct options. 1, either barely withdraw their appearances and exit the courthouse in advance of the hearing, or 2, participate in the 2 p.m. hearing in the courthouse where media cameras were installed, the national media was present, and law enforcement community was seated in the jury box directly behind the defense counsel table, at which time the court would read a prepared statement to the record and disqualify both attorney Rossi and Baldwin in the presence of defendant Allen and his family and the general public. 8. After waiting approximately 1/2 hour for defendant Allen to arrive at the courthouse, Attorney Rossi and Attorney Baldwin communicated with defendant Allen regarding the stark choice of the court had offered in chamber. Defendant Allen reaffirmed his desire to move forward under the representation of attorneys Rossi and Attorney Baldwin. Footnote 1. On October 12, 2023, Attorney Rossi filed correspondence with the court. Said correspondence contained a letter dated October 11, 2023, signed by the defendant Allen, wherein defendant Allen acknowledged that he was aware of issues regarding crime scene photos that were stolen from, maybe the footnote, Attorney Baldwin's office, and desired Attorney Rossi and Baldwin to continue the representation of him. So the defendant has made his wishes clear. As of October 24th, defendant Allen objects to the court's attempt to strip him of his current counsel, attorneys Rossi and Baldwin. 9. After speaking with Mr. Allen, attorneys Rossi and Baldwin then returned to chambers, at which time Attorney Rossi articulated to the court that the court had engaged in an ambush of defense counsel entirely devoid of due process, and Attorney Rossi would withdraw his appearance, but that said withdrawal was not a voluntary withdrawal because the court made it clear that if Attorney Rossi did not agree to withdraw, the court would publicly shame him in front of the world and his client before forcing him off the case by disqualifying him. 10. All of the events in chambers occurred without any formal allegations of contemptuous behavior by attorneys Rossi or Baldwin, without any pending pleadings requesting disqualification of defense counsel, and without any pending disciplinary complaints with the Indiana Supreme Court's Disciplinary Commission. 11. In total, attorneys Rossi and Baldwin have practiced law in the state of Indiana for more than 50 years without a single substantiated finding of disciplinary action against either. 12. At no time while in chamber did the court ever articulate to either Attorney Rossi or Attorney Baldwin that their conduct compromised defendant Allen's defense in any way. In fact, defendant Allen himself does not believe this to be the case. 13. There are no bona fide facts or circumstances wherein Attorney Rossi engaged in gross negligence, nor was there any showing that any conduct by Attorney Rossi resulted in negative consequences to another party, i.e., defendant Allen. In sum, attorneys Rossi and Baldwin did nothing to compromise Mr. Richard M. Allen's defense. 14. Attorney Rossi's oral acquiescence to withdraw his appearance as defendant Allen's attorney was coerced, forced, and driven only by the circumstances created by the tribunal, which delivered two terrible options: quit or be shamed in public before being, quote, disqualified, end quote, from representing Mr. Allen. 15. The court's premeditated ambush of the defense placed attorneys Rossi and Baldwin and the client, Mr. Allen, in a compromising position. The trial court stated the intention to read a prepared statement criticizing defense counsel created an impossible ethical bind. If counsel did not agree to withdraw in chambers, the trial court would publicly disparage the representation of the accused, framing their advocacy on his behalf as gross negligence, casting both counsel and the merits of their client's defense in a negative light. This public statement and circumstance created by the trial court risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly creating actual conflict for their continuing representation. 16. The jury trial in this matter is set to commence on January 8th, 2024, a full year and 3 months after the arrest of defendant Allen. The appointment of successor attorneys will prejudice defendant Allen by and through further delays in this case and trial. However, if attorneys Rozzi moves forward with his representation of the defendant, there will be no need for two newly appointed attorneys to dedicate hundreds and thousands of hours toward a mere review of discovery, which continues to pour in as recently as late September, there will be no need to marshal all discovery and return it to the prosecution. There will be no need to bring up to speed new staff members, investigators, and possibly a new set of experts to address the many complicated issues that have already been addressed by the defense. A new defense team would likely result in shifting of strategy and approach of Allen's current defense team, in which would further delay and compromise Richard Allen's defense. Finally, any successor lawyer would have the convenience of working with Attorney Rossi to become familiar with the subject matter in a much more efficient and fiscally responsible way. All these truths weigh in the favor of Richard Allen's choice to maintain Attorney Rossi as his counsel of record. 17. There are no circumstances under Rule 1.16 in the rules of Indiana Rules of Professional Conduct which warrant the withdrawal of Attorney Rossi's representation of Defendant Allen. 18. Attorney Rossi notices up this court of his intention to move forward with representation of Defendant Allen until final disposition of this matter. And that is what happened according to Mr. Rossi. But let's go back because there's more. There's always more. Okay, maybe it's this one. Aha. Ta-da. I am a genius. Stop screen, present screen. And we have this one. And in Begin, I am such a genius. Now, this is where things get a little spicy. This is a motion to disqualify the judge. Again, it's been yeeted, but it is going towards possibly the Supreme Court case. Motion to disqualify. Now comes the accused by counsel and pursuant to Rule 211 of the Indiana Code of Judicial Conduct and Rules 12B and D of the Indiana Rules of Criminal Procedure, respectfully, and moves for the recusal and change of judge from Judge Francis C. Gull. 1. Rule 211 of Indiana Code of Judicial Conduct requires a judge to disqualify him or herself when the judge's impartiality may be reasonably questioned, such is the case in the cause of action for the reasons described below. 2. Comments to the Rule 212 provide additional guidance. 1. Under this rule, a judge is disqualified whenever the judge's impartiality may be reasonably questioned, regardless of whether any specific provisions of paragraph A 1 through 6 apply. In many jurisdictions, the term recusal is used interchangeably with the term disqualification. 2. A judge's obligation not to hear or decide matters in which the disqualification is required applies regardless whether a motion to disqualify is filed. And 5, a judge should disclose on record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there's no basis for disqualification. 3. Judge Gull has removed and concealed or allowed to be removed by the clerk of Carroll County defense pleadings from chronological case summary in violation of the Indiana Supreme Court's administrative rules. Those pleadings include Frank's motion filed 9/18/23, Frank's memorandum filed 9/18/23, 3 affidavits, Warren Gallipew, Sergeant Jones, Sergeant Robinson, filed 10/10/23, the affidavit of the leaker, Mitch Westerman. Judge Gull has not removed or hidden any state filings. 2. Indiana Access to Court Records Rule 2A provides a pertinent part, quote, all persons have access to court records as provided in this rule, and that certain persons have greater access to court records. The commentary to ACR Rule 2A is that, quote, all persons, including members of the general public, the media, and commercial and non-commercial entities are entitled to the same basic level access to court records, end quote. And ACR Rule 4 provides that, quote, court record is accessible to the public except as provided in Rule 5. ACR Rule 5A provides that, quote, certain cases shall be excluded from public access without notice of exclusion, but, quote, this entire case has not been declared confidential, by statute or rule and meets none of the other criteria laid out in ACR Rule 5A. ACR Rule 5B provides the process for excluding individual case records. However, none of the 13 listed groups for excluding public access to the records secreted from docket in this case apply to the above referenced documents, which have either disappeared from the CCS or are inaccessible to the public, nor were the documents filed using procedures required by ACR Rule 5B, i.e., filing on green paper or filing electronically as confidential document, along with ACR form identifying the specific grounds on which the exclusion is based. By secreting pleadings from the docket without following the access to court records rules, Judge Gull has allowed violations of public access. Because those acts have only shielded documents from the defendant, these actions clearly demonstrate a lack of impartiality and fairness in violation of Judicial Rule 1, compliance with the law, footnote 1, and Rule 2.2, impartiality and fairness. So let's go to footnote 1. 1, quote, a judge shall comply with the law, including the Code of Judicial Conduct, and 2, a judge shall uphold the law and shall perform the duties of all judicial office fairly and impartially. You wouldn't think judicial would be a hard word to say, but it actually really is. I digress. 5. On October 12, 2023, Judge Gull instructed appointed counsel to, quote, cease work on Mr. Allen's case, end quote, which interfered with the attorney-client relationship and prejudiced the accused by denying him timely and effective representation guaranteed to him by the state and federal constitutions. 6. On October 19th, 2023, Judge Gull conducted critical stage proceedings in chambers outside the presence of the accused, even though she had ordered him transported and he was available. She then did the same after placing his attorneys in an ethical dilemma and again creating a public record outside the presence of the accused. This ignored clear precedent. 7. On October 19th, 2023, Judge Gull ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. The choice presented was to suffer a public shaming and be removed from the case or voluntarily withdraw. Despite defense counsel requesting clarification as to the topics or motions to be addressed at the October 19th, 2023 hearing, she gave defense counsel no notice of her plan to force withdrawals or remove them, thus denying counsel the opportunity to adequately refute her accusations. I can speak English some days. 8. The same day, Judge Gull had prepared a statement that she threatened to read to the public, alleging defense counsel was grossly negligent in the representation of defendant Allen. Judge Gull's complaint was more not about not having control over counsel rather than any legitimate concerns that counsel had engaged in conduct compromised Allen's defense. A general summary of Gull's complaints are as follows. A press release, quote, generic in substance, was issued by the defense in November 2022 before the court's gag order and only after repeated press conferences by the prosecution. Allen's response. The intent was only to level the playing field. This was well within the obligations of defense counsel by established guidelines. She never expressed any concerns over the multiple press conferences by the prosecution. B. 2 motions filed by the defense, one of which addressed the health and safety of defendant Allen, and the second of which addressed the immediate transfer of the accused due to the not so coincidental and undisputed fact of the individuals that individuals engaging in Norse paganistic practices may have not only murdered two girls, but were also escorting defendant Allen around the prison at the same time his health was in rapid decline. Allen's response: the court had previously ordered the accused transferred to a state prison at the request of Carroll County Sheriff. His mental and physical health began immediate decline. The prison guards in his areas had Odinist emblems on their uniforms, which endangered their client after the Odinist connection was exposed. The defense had videos of the patches, and the guards admitted they wore them. The defense had previously noted a connection between the murders and Odinism. The patches have since been removed. Mr. Rossi cited the instances of abuse. Those filings are within the obligation established guidelines imposed for effective representation. C. Mr. Baldwin drafted an email to co-counsel but sent it to the wrong person due to self-populating an electronic email. Allen's response: this was an accident that happens routinely to most people. The intended recipient, attorney Bradley Rossi, and the unintended recipient share the first three letters of their first names. The email attached contained no substantive information, just the bare bones outline of a teeny portion of discovery received by the defense in the case. D. The court alleged that Mr. Baldwin put improper statements in his Frank's memorandum, not false or misleading statement, just improper in her opinion. Allen's response: the court had disdain for the defense not filing it under seal, even though there was no order to do so. The memorandum was demanded by the prosecution before there could be a Frank's hearing. It was an impressive piece of legal writing and has been lauded by expert defense counsel across the nation. It again was required by applicable guidelines. E. That Mr. Rossi had filed a tort claim notice to preserve the rights of his client. The court opined that this action amounted to gross negligence. Allen's response: the filing of the notice was intended to preserve the rights of a man who was shuttled off to one of the most secure detention units in the state, locked up and isolated with only a tablet, which often was dysfunctional, to communicate with the outside world. Allen had no ability to speak with his wife in private, as his phone calls were being recorded. Allen's own attorneys were required to make advance reservations to visit him in prison. It was entirely impractical that Allen would have had the means to prepare his own tort claim notice or to secure a private counsel to do so. F. Mr. Baldwin had hired a lawyer to represent him in this matter. Allen's response: this was not true. Mr. Baldwin was betrayed by a friend, and there was a subsequent related suicide. As a friend and colleague, David R. Hennessy suggested he needed a lawyer to speak on his behalf, and he volunteered. No fee was arranged between the two. The court also alleged the undersigned put volatile facts in the memorandum regarding possible sanctions or disqualification. The true facts in the criminal case are often volatile. There were no untruths. G. Dissemination, quote, unquote, leak of the crime scene photos in which neither Attorney Rossi or Attorney Baldwin had knowledge nor participated in. Allen's response: see affidavit of Mitch Westerman previously filed. 9. Guideline 1 of the Indiana Public Defenders Council Performance Guideline for Criminal Defense Representation states, quote, the paramount obligation of defense counsel is to provide zealous and quality representation to their clients at all stages of criminal process. Similar obligations are recognized by the American Bar Association, the Legal Aid and Defender Association, the National Advisory Commission on Criminal Justice Standards, and Goal and Rule 1-1 IRPC. 10. Everything cited by Judge Goal as concerning was either not attributable to Attorney Rossi or excellent ethical lawyering in the best interest in clients' defense and mental and physical well-being. 11. Throughout the pendency of this proceeding, the defense has exposed untruths by law enforcement, withholding of exculpatory evidence by the prosecution, and discovery violations about which Judge Gull has shown no concern and did nothing. 12. The court has routinely expressed umbrage at the defense counsel's representation through investigations and filings while silently abiding the prosecution's discovery delays and false statements by them or their agents. 13. On October 19th, 2023, Judge Gull coerced an oral request to withdraw from Attorney Rossi that did not comply with Rule 3.8H, Rules of Trial Procedure, and further coerced an oral request from Attorney Baldwin to withdraw as co counsel in this case. 14. Judge Gull has exhibited a lack of concern about and taken no action to protect the physical and mental health of the accused. 15. Throughout these proceedings, Judge Gull has exhibited bias and prejudice against the accused, his attorney, and in favor of the prosecution. 16. Counsel for the defendant are appointed pauper counsel, and upon appointment, judicial control and oversight of the appointed counsel is inappropriate. The court cannot and should not dictate the process of representation and improvidently curtail representation of counsel. It has done so without notice to the defendant or his counsel, affording them an opportunity to be heard. Or without notice to the defendant or counsel, affording them an opportunity to be heard, it has also done so of its own accord without any precipitating motion or request. No due process has been afforded. 17. Rule 211 of the Indiana Code of Judicial Conduct requires a judge to disqualify himself or herself when the judge's impartiality might reasonably be questioned, such is the case in this cause of action for the reasons described below. 18. Rule 212 of the Indiana Code of Judicial Conduct states, quote, a judge shall act in all times in a manner that promotes public confidence in independent integrity and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. 19. As previously stated, Judge Gull strong-armed attorneys Baldwin and Rossi with a prepared statement that she intended to read into the record that had either attorney resisted her efforts to remove them from the defense. Within minutes, Judge Gull took the bench, started the record, and informed those present and the viewing public that there had been an unexpected turn of events with the defense team withdrawing from the case. Judge Gull further stated that these circumstances were, quote, clearly outside our control. The only clarity offered up by these statements is that they were entirely inconsistent with her actions in the chambers just minutes earlier that forced attorneys to consider withdrawal in this matter. These words run afoul of Rule 2.1 as they demonstrate the tribunal's lack of integrity and impartiality toward the public and usurp defendant Allen's right to competent legal representation. 20. Rule 22 of Indiana's Code of Judicial Conduct requires that, quote, a judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Comment 1 to the rule states, to ensure impartiality and fairness to all parties, a judge must be objective and open-minded. Rule 21, Rule 2.15 of the Indiana Code of Judicial Conduct in pertinent part states, B, a judge having knowledge that the lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthy, or fitness as a lawyer in respects shall inform the appropriate authority. It does not indicate any such opinion of the court allows removal of appointed counsel without due process against the wishes of the accused. 22. Judge Gull has violated Rules 1.2, 2.2, 2.3, 2.6, 2.8, and 2.11 of the Indiana Code of Judicial Conduct. Bradley Rossi has signed this, and I believe this has also gone to the Supreme Court. These are some fairly spicy and damning motions. According to my appellate attorney friend, again, she has a lot more experience with these motion things. These seems pretty spicy to me. This judge seems like a total well, Hagatha, if you want to ask me. But again, I encourage you to find other sources of information to make up your own opinions because we all need to have, not our echo chambers. I am a mouthy redhead on the internet, but you need to listen to other mouthy people on the internet that may not have red hair. So that is this video. I hope that this has brought a little bit more clarity into this rabbit hole of a dumpster fire on a nuclear volcano of a case. I'm sure by the time I get done, downloading this, there will be another 27 updates to this case because that is just how it's going lately. But that is the update for today. I hope to see you at Nightly Newsy News. I have got to go run and find some Nightly Newsy News. Say one kind thing to yourself and one kind thing to someone else. Have a wonderful rest of your evening. If I don't see you again, like and subscribe and share with your friends. Have a wonderful evening. I will see you guys in a little bit. Bye, guys.